Well, hello and welcome once again to this session. Welcome, everyone. You are here watching and listening to the Employment Law Q&A session. For those wondering who I am, well, first of all, nice to meet you. My name is Lior Samfiru. I'm the employment lawyer. I am here to answer your questions. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employment law firm in Canada. We operate in Ontario, in BC, and in Alberta. And what I like to do every Wednesday at this time is I like to log on here and open up the floodgates to your questions. So if you have a question, an issue surrounding employment law, a dilemma, you're dealing with a deadline, an ultimatum, a threat, you lost your job, are being mistreated in the workplace, vaccine related, whatever the issue, whatever the question, what a great opportunity you have to type in that question. I'll see it, I'll answer it, and then you can turn off your browser knowing a lot more than you did before. So again, my name is Lior Samfiru. I'm the employment lawyer, and I want to make sure that you get answers to your questions. Don't be bashful. We always have people that don't get to ask their questions because they waited too long to type them in. Don't do that. Ask your questions. You got time right now, and I can see them and answer them. Before I get started in answering the questions, let's make sure that you have some other contact information as well. If you want to reach out to me or my team off social media, you want to have a private discussion or a private email exchange, very, very easy to do that. All you have to do is you have to go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address below me. And that is your gateway to contact me and my team. Phone numbers, email address, forms you can submit. Everything is right there, employmentlawyer.ca. So on social media, I can't actually help you. I can give you answers, but I can't do anything for you. If you need me or my team to actually do something for you, to help you enforce your rights, employmentlawyer.ca is the place you go to. But that's after. Right now, I'm live, you're live. Ask your questions. Employment law is what we're here to talk about today, and I'll get started right now. Okay. From M. Ellie, are long-term care workers still mandated by the government to be vaccinated? I can't find this info online. Yes, as of now, they're still required by the government to be vaccinated. Keep in mind, if you're part of a union, talk to your union about that. But right now, that's still the case. Mark Joel, I was terminated because of a mandate without a cause. Well, Mark, if you're not part of a union, then you are owed compensation. And depending on the type of job that you had, how long you've been there, and even your age, you could be owed as much as 2 years' pay. And by the way, EI as well. You're going to have to get employment insurance. So chances are that you either receive nothing, or whatever you've been offered is a lot less than what you're owed. And you probably also didn't get a proper record of employment so that you can't get EI. Well, we can deal with all that, right? We can get you the compensation you're owed. We can get you a proper record of employment so you can get EI. So what you need to do, Mark, is do exactly what I was saying earlier. I can't actually enforce your rights on social media. You need to reach out to me directly. So I want you, Mark, to go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that right there, right there. And you can contact me there, phone, email, whatever you want. Okay, so Mark, thanks for joining me today. Take the next step and reach out. Alicia, so first of all, you're talking about, I think you're talking about federally regulated employees. So let's be clear. The federal government did not follow through on implementing a mandate for federally regulated employees. They did not do that. They said back in December that they're going to be doing that for all federally regulated employees. They have not done that. I don't think they're going to do that because now the trend is to open things up and to have less mandates. So if you're a federally regulated employees, most employees are not, there's no vaccine mandates. There's a vaccine mandates for those in the transportation industry, so airlines, railway, etc., and for certain core government employees, very small number. So for most people, if you work for a bank or trucking or telecommunications, there's actually no vaccine mandate, okay? So if you do lose your job because your employer decides to have their own mandate, okay, but they have to pay you compensation. They have to pay you severance. They have to do that. So very important to remember, a lot of people assume that because the government said that they were going to implement a federal mandate, that they did that. They never did that, okay? Okay. So, Mark, you say that you haven't received unemployment. I just answered that. You're absolutely ODI. You know what to do now. You reach out to me. Next question on YouTube from JC2004X. In the event of seeking new employment after recovering from a vehicular accident, what rights does an employee have for accommodation? You have the right to be accommodated, and your doctor is the kind of judge and jury when it comes to what accommodation you need. So if you need modified duties, modified hours, you need gradual return to work, whatever the thing is, you need your doctor to put that in writing and give it to your employer. Once your employer has that from your doctor, they have a very strict legal obligation to provide that accommodation. It's not up to them. They can't say no. They can't say we don't want to. It's not even good enough for them to say it's too difficult. They have to accommodate. Now, if it's impossible, if it's so hard and so expensive, yes, they may not have to go that far. But it's a very high standard. And in my experience, a lot of employers just don't want to work hard enough to provide that accommodation. So if you have that doctor's note requiring or outlining that accommodation and your employer won't do it, you know what to do. You reach out to me. Okay. Usually I can give them the kick in the pants, or that could be a human rights violation, a constructive dismissal. There's a lot that we can do, but you need that doctor's note. Okay. And to reach out to me, you see that address, employmentlawyer.ca. For those joining us, again, welcome. My name is Lior Samfiru. I'm the employment lawyer, and I'm here live right now, as you see me, answering your questions. I'm with Samfiru Tumarkin LLP, the largest employment law firm in the country, and I'm here live answering questions. So ask those questions. I can't answer them if you don't ask. I'll continue answering right now. Let's see. Alicia Bolton. Are there any cases in litigation where an employer has mandated the vaccine, where an employee feels they have to get vaccinated, where they got the vaccine and they had a severe reaction, they are now suing their employer? No, there are no cases like that. And I don't think there will be, because you wouldn't be able to sue your employer in that situation. If you got the vaccine because of your employer's mandate and then you got sick, no, you won't be able to sue your employer. There's many, many cases, and I'm dealing with hundreds of them across the country, where there's legal action over the payment that's owed the employee if they lost their job. Those have been resolving and are settling on good terms. But no, you're not going to be able to sue your employer if you have a reaction to the vaccine. Let's see. JC 2004. I could see how a new employer might not want to hire under the terms that alter job description or give extra breaks. Would they be liable for discrimination? Yeah, absolutely. And in fact, what you can also do is, after you've been hired, then tell your employer what accommodation you need. So absolutely, that's very common actually to have these types of discrimination cases. Next question comes to us on Facebook from Valerie. My non-union employer, bottling company, has decided to add a policy to have everyone vaccinated. They are pressuring me too. So ultimately, okay, so there's a follow-up. They're pressuring me to get vaccinated. I don't want to, but I'm scared of getting fired. My question: has your firm won any cases like this? If it's not, if it's for sure thing, I'll get compensation. I'll let them fire me. So you have to make the decision between what's better: keeping your job and getting vaccinated, or not getting vaccinated and then losing your job with compensation. Yes, we've represented, as I've said, hundreds of people across Canada in exactly this situation. And yes, we've won and we've resolved many cases. When I say won, I'm saying we've gotten really good results for our clients. Now, I don't know enough about your situation, your employer, etc. So you need to reach out to me. So you don't need to make any decisions right now on social media. Let's talk. Okay, reach out to my firm. We'll have a discussion and we'll tell you, yes, you have a surefire case or you don't have a surefire case. But ultimately, you will have to decide, are you willing to lose your job? You cannot physically stop your employer from from letting you go. So just reach out to us and let's have that chat. And Valerie, and we'll go from there. Again, to reach out to me, for Valerie, for everyone, employmentlawyer.ca, employmentlawyer.ca. That's your gateway. Phone numbers are there. Email addresses are there. Everything is there. So check it out. Let's see. Okay. M. Ellie. can a long-term care worker get EI after being put on unpaid leave for not being vaccinated? So in this case, you probably wouldn't, because there's a mandate, a government mandate for long-term care employees. That means that if you're not working, it's not your employer's fault. They don't have a choice in the matter. So if you're not getting vaccinated, despite there being a government mandate, chances are you're not going to qualify for EI. It's very different if there's no government mandate and the employer decides to implement a mandate. In that case, if you lose your job or are put on a leave, then yes, you absolutely should qualify for EI. So the question always is it a government requiring my employer to do what it's doing, or is the employer deciding on its own, it's choosing to do what it's doing? Okay, hopefully that makes sense, Valerie. Garcia on Facebook, how long can you be on a leave of absence? That assumes that you can be on a leave. You can't. In other words, if you're put on a leave of absence, you can treat that as a termination on day 1. It doesn't only happen after day 10 or day 100. Whenever you're put on a leave of absence, you have a choice to make. Choice number 1 is you can stay and wait to see what happens. Wait to see if you get called back to work. Maybe it's a day, a week, a month, a year. I don't know. But that's your option. The second option is you can choose. You can decide to say that leave is a termination of employment. We call that constructive dismissal. You can decide to do that whenever you want. And then you can pursue and get your full severance. So that's the options if you're put on a leave of absence. So it's not about how long can you be on a leave of absence, because they don't actually have the right to put you on a leave of absence without pay in any event. Hopefully that makes sense, Garcia. If not, ask a follow-up question. And again, to reach out to me for Garcia, for everyone, employmentlawyer.ca. Again, employmentlawyer.ca. You see that address below me. That's your place to go to. Antoinette on YouTube. They sacked me from work after all the written information that was given. Okay, you know what to do. You're here means you know what to do. You reach out to me. I assess whether they had good cause or not, what you're owed, what you're not owed, is it a human rights violation, and how do we proceed with that? So obviously, I don't have the information and I can't represent you on social media, but yeah, if you lost your job, I don't care the circumstances, you got to reach out. So Antoinette, social media is great, but you need to take that next step. Okay, you need to go to employmentlawyer.ca. You see that address right there below me. Fill out a form, send an email, make a call, whatever you're comfortable with, and let's get going. Next question from Mark. Can a future employer discriminate if you're not vaccinated? Well, a future employer can decide that to hire someone, we need that person to be vaccinated. Yes, they can do that in most cases. All right. And in fact, what you may see from now on is a lot of employers doing that, or having an employment agreement saying that by accepting the job, you confirm that you've been vaccinated. So that could happen. Absolutely. Let's see. A long question from Anne-Marie. Let's see if I can get through this. I'm on leave and STD ran out February 15th. I'm appealing LTD as I was denied. I went on leave due to stress directly related to my boss, who's a bully. She has had a number of people leave the company. I have spoken with HR starting well before I went on leave about my concerns. I'm ready to go back to work, but cannot work for her as it would not be good for my mental health. If I'm denied LTD, what are my rights? My doctor supports me. So first of all, the LTD appeal is a waste of time. You're not going to get it, okay? You're appealing to the people that have already denied you. It's just a mirage of false hope. So what do you do with respect to LTD? You let us deal with it. We have a whole department at the law firm just dealing with this, okay? Because they can ignore your doctor and they can ignore you, but they can't ignore us. So those appeals, everyone tries them. It's a waste of time. So let us deal with the insurance company. Now, with respect to your employer, is if you can establish that you were harassed, you were bullied, then you may not have to go back and you can still be owed compensation. Keep in mind, this bully that you're talking about is not going to admit, right, that they've done it. They're not going to admit it. They're going to say, never happened. I don't know what you're saying. So how do we prove it? Are there emails? Are there recordings? Are there witnesses? Is there something? If there is, we're in business. We can get going. You don't have to go back. You can get compensation. If there isn't, you may want to consider going back. And if the bullying continues, let's start documenting something. Let's create records, recording. Let's send emails confirming what happened. Let's build that case so that we can do something about it. Okay? So Anne-Marie, with respect to LTD, you're not going to, your appeal is not going to be successful, but not a problem. We deal with that every single day, hundreds of times. So let's talk about that. Let's deal with your insurance company. And with respect to your employer, do we have the goods? Do we have the evidence? Hopefully that makes sense. Jessica Novak on YouTube. How long does it take to get to court? I'm not vaccinated, got fired, have a lawyer from your team. I'm not getting EI. I know she said up to a year, but I have no money. So the vast majority of these cases settle well before you go to court, 99% of them. Okay, I expect yours will as well. I don't know enough about your case to say, but the majority settle before, and our job is to resolve them quickly, and that's what we're going to do in your case and in every case, and we've already been doing that successfully across Canada. Let's see. Rocket on YouTube asks the next question. Are there any questions an employers are not allowed to ask during an interview? For example, can they ask how old you are? Great question. So they're not allowed to ask any questions that touch on a prohibited ground. So no, they can't ask about your age. They can't ask about your ethnicity. They can't ask about whether you're pregnant. Age, of course, is the big one. They can't, because why? It's not relevant. Okay, the law says that someone's age is not relevant and shouldn't form part of the hiring decision. Whether someone is planning on having children is not relevant. Whether someone is Jewish or Muslim or Christian doesn't matter. It's not relevant and shouldn't be part of the decision making. So it's inappropriate to ask those questions. So age, religion, ethnicity, marital status, pregnancy status, all of those are offside. And just that question could be considered a human rights violation. So Rocket, hopefully that makes sense. Great questions today, guys. And for those just joining us, I'm Lior Samfiru, the employment lawyer. I'm here live answering your questions. So ask them. You have some time left. And of course, to connect with me off social media, to have a private discussion and to get to work on actually helping you, employmentlawyer.ca is the place to go. Let's see. Shah Inur on YouTube. Company always late in paying wages. Stress put me in hospital twice and once in a coma. Wow. Off work for a month. They refuse to accommodate. Well, you know what? That's too much for me to be able to deal with right now. You obviously have legitimate and important legal concerns and legal rights. So I'm going to leave it to tell you to contact me. Okay? Not next week, not next month, now. Okay? Reach out to me through employmentlawyer.ca. Let's have that discussion and let's get going. Okay? There's nothing more that we need to say here on social media. You want to reach out to me as soon as possible through employmentlawyer.ca. Let's see. Next question is from King Awesome on YouTube. My employer reversed its vaccine policy and is now offering me my job back. I've already changed jobs and never want to go back to that company. How will that affect my claim for severance? So it could reduce the dollar value of your claim depending on how long you were off work, depending on whether you're making the same amount of money, less or more money. So yes, it could impact that. So use a simple example. Let's say you were off work for 2 months as an example, and then after 2 months you found another job. It's possible that your entitlements may be limited to 2 months. Now that's oversimplifying, and it's not exactly like that. I'm just giving you an example. So the best way to know what you're owed and how that impacts you, just call us. Okay, go to employmentlawyer.ca, make the call, send the email. Let's have that chat so we can assess your matter properly. Okay. Let's see. JC 2004. In the event a government backs down on a mandate, is back pay of VI then paid to the employee? No. If you initially lost your job because of a mandate, there would be no back pay of VI unless the governments create a law saying that EI has to pay you back. But no, it's not. That's not going to happen. Okay. Next question from Patricia or Patrizia. On Facebook, I'm being threatened by my non-union employer to be put on a leave without pay by May 2nd if not fully vaccinated. Can I hire your firm to send a letter stating I want to keep my job, or the alternative is severance? I'm owed plus damages. I won't go after them hard as they have discriminated, are unethical, and refuse my religious. I want to go after them hard. So you have to call us, okay? There's nothing that you should do on your own, nothing that you can do on your own. You need to contact us as soon as possible. Not if your deadline is May 2nd, don't wait till May 1st. Okay, contact us now. Let's have that discussion. Employmentlawyer.ca. We act for, as I said, hundreds of people in exactly that situation across Canada. So please reach out to us, employmentlawyer.ca. Let's see. Next question here is from Christine on Facebook. But I've been on LTD for 2 years. This month is the beginning of the any occupation definition with my insurance provider. It's the end of the month. I sent all my documentation from my doctor, but I still have yet to receive this month's benefit payment. Should I be concerned? A lawyer is already fighting for me for my CPP case with the tribunal and assures me that we will win. Well, I can't say anything about your CPP. I don't know. But should you be concerned? Yeah, you should be, because at the 2-year mark, where the criteria to qualify for a long-term disability change is when a lot of people get cut off. Okay, so you should be concerned, but getting us involved on time helps. Oftentimes, just getting a letter from us to your insurance company gives them enough of a warning not to mess with you, if you know what I mean. And then they don't cut you off. But even if they do cut you off, we get involved to get you back or to get you compensated. So yeah, there's probably a decent chance that you get cut off, because it happens all the time at that 2-year mark. But that's okay. It happens all the time. We deal with it. As I said, we have a whole department just dealing with long-term disability claims, a whole department. So let's talk about that. Reach out to me and my team, employmentlawyer.ca, Christine, and we'll go from there and we'll help you. Okay, a lot of long-term disability questions today. That's awesome. From Mary on Facebook. I'm on LTD. I was approved for 2 years. After a year, the insurance company sent me a form to sign, but I didn't sign because I'm depressed and lost my weight, and they contacted my doctor. Again, I don't know what the form is. I can't say. So you need to contact us. I don't know if there's been any consequences for not signing. So obviously, I would need much more information. Let's see. Rocket has a follow-up. If the employer does ask those illegal questions in an interview, how do you respond, or should you respond? Well, you shouldn't. You can say it's not appropriate, and that's really all that you can do. I mean, you can respond. There's no law saying you can't, but you don't need to. You don't have to, because it's an inappropriate question. Okay, it's a discriminatory question and arguably a human rights violation. Now, before we continue, let me give you another tool that you must be aware of. If you lost your job, if you think you will lose your job, if you believe that you're going to be put on a leave, or that you're dealing with a constructive dismissal, you need to know what you are owed. You need to know how much compensation, how much severance you're owed. So easy. To do that, you can do that now. Use our severance calculator. To do that, you simply go to pocketemploymentlawyer.ca. You see that address below. I'll give it again. It's pocketemploymentlawyer.ca. And you'll see our severance calculator. The first thing you'll see there is our severance calculator. You click on it, and you can find that you answer 3 questions, and you'll find out how much severance you are owed. By the way, it's not a week per year of service. It's a lot more. You could be owed as much as 2 years paid, 24 months. Okay, it's free. It's anonymous. You don't have to put in any information about the company name. You don't have to put in your name. You don't have to put in your address, nothing. Okay, so use that. It's the very first place you go to if you're even thinking that you may be out of work. You go to pocketemploymentlawyer.ca, use our severance calculator. By the way, there's a lot more other things that you can do with pocketemploymentlawyer.ca, but certainly when it comes to severance, that is the place you go to. And tell others about it as well. Maybe you're talking with your neighbor down the road who is telling you, my gosh, I'm losing my job, vaccine, or other reasons. You tell them right now, you grab your smartphone, you go to pocketemploymentlawyer.ca and you use the severance calculator. All right. Have a few more minutes. Let's see if we can get some more questions in. All right. From MLE. Is there anything a long-term care worker can do to get compensation from being placed on a leave? Not until there's no more government mandates with respect to that specific job. Next question on YouTube from Julia. I work 2 jobs and I'm likely to lose one because they are closing my branch. Am I entitled to any severance if I'm still employed at my other job? So I'm not sure if you mean 2 jobs with the same company or 2 separate jobs with 2 separate companies. Okay. If it's 2 jobs with the same company, you can treat your employment, all your employment, as being terminated and get constructive and get severance. We call that constructive dismissal. But you'd have to decide, do you continue working or not? If it's 2 separate jobs with 2 separate companies, then yeah, one does not impact the other. If you lose it, you're owed severance. And again, you can go to pocketemploymentlawyer.ca to find out how much severance you're owed. That second job won't impact that at all. Let's see, continuing. By the way, guys, we have like 3 or 4 minutes. If you have last minute questions, don't wait, ask right now. Bubba Wilson, love that name, on YouTube. My friend got laid off and there was a 3-month probation. He was laid off before the 3 months were up. So first of all, the key here when it comes to probation is for me to see a copy of the employment agreement that your friend signed. If they signed an employment agreement that said, in the first 3 months, we can let you go without compensation. If it said that, then he can be let go in the first 3 months with no compensation. If it didn't say that, if it didn't say anything, or if it simply said you're on probation, but didn't say that we can let you go without compensation, he's absolutely owed severance even in the first 3 months. And by the way, even in the first 3 months, he could be owed as much as 2, 3, 4 months of severance. So the key here is the terms of the employment agreement, okay? That's what I need to see to be able to assess what your friend is owed. So what do you do right now? Well, Baba, you tell your friend to contact me as soon as possible through the website that I just gave you, employmentlawyer.ca. Phone numbers there, email address, your friend can reach out and we can connect and do what we need to do. Again, employmentlawyer.ca. So after, okay, next question, sorry, from Luco on YouTube. After unsuccessful negotiation within my HR severance pay, can I restart my negotiation with your lawyers? Absolutely. Usually it's a bit of a waste of time for you to try to do that yourself. The reason why we have 45 lawyers across Canada is because we need to get involved. But unless you sign something that gave up your rights, yeah, no problem. We can get to work right away. So yeah, let's talk as soon as possible. Luco, you want to reach out to me, employmentlawyer.ca, and let's get to work. Christine says, the lawyer fighting for my CPP is hired by my insurance. Of course, yes, they want me to get CPP and are paying for their lawyer. Can they still cut me off? Yes. Well, it's not a question of can they, it's a question of will they, okay? They probably will. Can they or should they? No. But if they do, you reach out to us so we can get to work. See, I'll take one more question. Okay. From Frederick, is employee misclassification retroactive? Does CRA need to be informed regarding taxation issues, or is Ontario labor enough? Not sure exactly what you mean. If you've been misclassified as a contractor, it depends. I mean, if your job changed, you could have been an employee for a month, for a year, for forever. So I'm not sure exactly what you mean there about CRA, but again, being misclassified is very common. Oftentimes people are treated as contractors, but they're really employees. So they have the rights of employees in terms of minimum wage, vacation, overtime, severance, termination. So definitely that's a common thing. If you're not sure what your status is, always reach out to me as soon as possible, employmentlawyer.ca. Okay, I'm going to catch my breath. That is the time that we've had for today. Always a great thing for me to be here. Always exciting to do, and I enjoy doing it. For those not sure, again, who I am, Lior Samfiru is my name. I'm the employment lawyer partner at Samfiru Tumarkin LLP. I was here answering your questions. I'll be back, okay? But don't wait until the next time you see me or one of my colleagues on social media. If you have an issue that needs to be addressed, do that now. Contact me, contact my team through employmentlawyer.ca. Don't wait. Don't say, I'll just get them on social media. We can't act for you on social media. We can't actually get anything for you. For that, you have to reach out to us. So do that at employmentlawyer.ca. Until next time, always a pleasure, guys. Thank you. Take care of yourselves, and we'll talk soon. Bye-bye.